Okay, we're in session in cause number 329-028 and cause number 330-150. Board cases are style the state of Texas versus Adam Brock Cormier. We have Mr. Cormier, okay, his mic is on mute. Could have somebody to put Mr. Cormier, okay, there it is. Mr. Cormier, would you please raise your right hand? Mr. Cormier, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Okay, Mr. Cormier, you may put your hand out. How you doing, Mr. Cormier?
I'm here.
Okay, that's good. Now, Mr. Cormier, you're represented in your cases by your attorney, Mr. Ryan Matuska. Mr. Matuska, how are you doing?
Morning, Judge.
Good morning. Mr. Matuska, do you wait? You're not taking it, are you? You are, okay. Mr. Matuska, Mr. Cormier, I have before me an information in cause number 329-028, and in this information, it alleges that on or about October 25th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of a controlled substance. Mr. Cormier, do you understand what you've been charged with?
Yes, sir, Your Honor.
And to this charge, Mr. Cormier, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're guilty?
Yes, sir.
Okay, now, Mr. Cormier, I also have before me a document that is titled the misdemeanor plea admonishment. On page 2 of this document, Mr. Cormier, there are a set of initials, AC, on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, Your Honor.
And on the third page or the next page of this document, there's a signature above the line that's titled defendant. Is that your signature?
Indeed, sir.
And on the next document, which is titled the trial court certification of defendant's right of appeal, there's a signature at the bottom of this document. Did you sign this document? Above the line is titled defendant.
It is, sir.
And there are 2 boxes that are checked. At the top of this document, the first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir, Your Honor.
The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, Your Honor.
Now, Mr. Cormier, on yesterday, which was October the 7th of 2021, I had you signed a document that is titled the discovery certification. Is that correct?
Yes, Your Honor.
Now, Mr. Cormier, prior to signing and initialing these documents that I've just mentioned, did your attorney go over these documents with you?
He read them to me.
Okay, so he went over those documents with you?
Yes, Your Honor.
And did you read and understand everything in these documents?
Yes, Your Honor. Am I able to keep those paperwork, that paperwork?
Yeah, you can keep it. Now,
Judge, he's talking about all the evidence in the case.
I thought you was talking about the paperwork that you signed, like the
Yeah. I don't get the evidence against me. I can't keep that.
Your attorney could tell you about the rules of the rules of evidence, the rules of discovery, and he can tell you about what it says. Okay.
Your Honor, I have made it clear to Ms. Cormier that the discovery rules under 3914, I do have those in my file, and he is welcome to those, but I can't provide him to those here at the jail right now.
Well, just you just follow the rules as they are printed in 39.14 of Texas Code of Criminal Procedure. Okay. Now, Mr. Cormier, let me just ask you, I've already asked you, did you read and understand everything that?
Yes, sir, Your Honor.
Initials, and is everything true and correct to the best of your knowledge?
It is.
Okay, state, I have before me state's exhibit number 1, State, you like to offer State's exhibit number 1?
Yes, Your Honor.
Any objections, Mr. Matuska?
No objection, Your Honor.
Okay, no objection. State's exhibit number 1 will be admitted. Okay, now, Mr. Matuska, you advised in counsel, Mr. Cormier, is there any evidence that he's currently mentally incompetent to stand trial?
No, sir, Your Honor.
Okay, Mr. Cormier, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
For the most part, yes, sir, Your Honor.
Has he provided fully effective and competent legal representation?
For the most part, yes, sir, Your Honor.
Mr. Okay, Mr. Cormier, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 90 days probated over 1 year, a $500 fine, and 40 hours community service. That's to run concurrent with cause number 330150
Hold on, 330150.
and cause number 21
21
dash 36780.
36780. Okay. Okay, Mr. Cormier, the state is offering that you serve 90 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs.
I'm sorry, Judge, that felony number is incorrect.
Okay, okay, what's the felony number?
It's 21-36540.
36540.
Yes, Judge.
2-1, okay. Now, okay, that's gonna have to be changed in the, okay, just,
I apologize.
Hey, Julie, I wrote the $7-8 a month there for
Yeah, it was a different felony. That one got dismissed, so we need to.
you. Oh, okay.
okay. All right, now, Mr. Adams, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be on probation for 1 year. During the probationary period, you'll be required to pay a fine of $500 plus court costs of $502. The total fine and court costs is $1,002. You'll also be required to pay a fee of $100 to reimburse the crime lab. You will not be required to pay any restitution or any probation fees in this case. And you will be required to pay a urinalysis fee of $15 each month. You'll also be required to reimburse Jefferson County for the court-appointed attorney's fees of $50. Your total monthly installments for this case will be $115 per month. Mr. Cormier, would you be able to pay the $115 per month?
I mean, I'm not sure what's gonna happen at that point, but I believe I'll be able to do that. It shouldn't be too much.
Okay. Now, so you will be able to pay the $150
Yes, sir.
per month?
Yes, sir.
Mr. Cormier, you also be required to perform 40 hours of community service. And this case will run concurrent with cause numbers 330150 and cause number 21-36540. And you also be required to adhere to the other standard terms and conditions of your probation. Mr. Cormier, do you understand the state's offer?
Yes, sir. If I wasn't able to pay the $100 and some dollars, because I don't know if I'm gonna have a job whenever I get out.
Okay, well, let's back up then. Now, Mr. Cormier, I have before me an affidavit of indigence that was signed by you July 27 of 2021. And actually, at that time, you stated to the court that you was going to hire an attorney. Let me ask you this here. Now, Mr. Cormier, are you employed?
Not anymore, sir.
Okay, that's what I need to know. Okay, so you have no source of income, is that correct?
Yes, Your Honor.
Okay, now, do you receive any type of governmental benefits like Medicaid, SSI, SNAP, TANF, or do you live in public housing? No?
Yes, sir.
All right, now, do you have
Well, I get
expenses?
food stamps.
Oh, you do? Okay, that's SNAP. Okay,
Yes, sir.
well, because you get food stamps, you are an automatic qualifier. So that, what I mean by that is you meet the eligibility requirements because you are determined to be indigent. And so based on that determination, the court is going to find that you are indigent, and the court costs, not the court costs, but let's do this here. Okay. The fine and court costs of $1,002 is going to be converted to community service, and you'll be required to perform 80, that's going to be converted to 80 hours of community service. And you don't have a probation fee here. And so basically, with this punishment, you will not be required, your $1,002 fine and court costs is going to be converted to community service. So you'll be required to work off the fine and court costs by doing 80 hours of community service. That's in addition to the 40 hours of community service that that you have. Okay, do you understand that?
Yes, sir, Your Honor.
Okay, so the court is going to find that you're indigent pursuant to Article 42.15 of the Texas Code of Criminal Procedure. And with that finding, the fine and court cost is going to be converted to 80 hours of community service. Now, Mr. Cormier, do you understand the state's offer?
Yes, sir, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, sir, Your Honor.
Now, Mr. Cormier, you will also be required to adhere to the other standard terms and conditions of this probation. And as I said earlier, I'll repeat it, that this case is going to run concurrent with cause number 330150 and cause number 21-36540. Hey, Mr. Cormier, do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Cormier, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Cormier, we will move on to your next case. And your next case, Mr. Cormier, is cause number 330150. And Ms. Cormier, in this case, the state alleges by information that on or about August 8th of 2019, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of possession of a controlled substance. Mr. Cormier, do you understand what you've been charged with? Mr.
Yes.
Cormier, do you understand? And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you pleading guilty freely and voluntarily?
Yes, sir. I only have information on cause number 329028. I don't have any information on the other stuff.
What you mean, but you don't have information?
Judge,
Yes, sir, Your Honor.
I printed out for him the information that I had. It wasn't both of them. It was the information on both cases for evidence, but it was only one information. So he's holding one information in his hand.
Oh, you're talking about the information?
Yes, sir.
Oh, that's the charging instrument.
Yes, sir.
Okay, well, let me, is that subpoena? If you would like, I could read this information to you.
It's fine, Your Honor. I'm going with the plea bargain.
Okay, so now let me do this here. The information in cause number 330-150 alleges that on or about August 8th of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of a controlled substance. Do you understand what you've been charged with?
Yes, sir, Your Honor.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, now, Mr. Cormier, I also have before me a document that is titled the Misdemeanor Plea Admonishments. And on this document on page 2, there are a set of initials on a line, and the initials are AC, ABC, and it's on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, Your Honor.
And on page 3 of the same document, there's a signature above the line that's titled defendant. Did you sign this document?
Indeed, Your Honor.
And on on the next document, which is titled the trial court certification of defendant's right of appeal, there's a signature below on the line that is titled defendant. Did you sign this document?
Yes, Your Honor.
Now, there are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
And the second box states that you are waiving your right to an appeal. Do you understand that?
Yes, Your Honor.
And Mr. Cormier, did you sign a document that is titled the discovery certification
Yes, sir.
on paper on yesterday?
Yes, sir.
And now, prior to signing and initialing these documents that I've just mentioned, did your attorney go over the documents with you?
Yes, sir, Your Honor.
And did you read and understand everything in these documents?
Yes, sir, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Indeed, Your Honor.
Okay, now, State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
Any objections, Mr. Matuska?
No objections, Your Honor.
Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Matuska, you've advised and counseled Mr. Cormier in this case as well. Is there any evidence that he's currently mentally incompetent to stand trial?
No, sir, Your Honor.
Okay, Mr. Cormier, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
For the most part, yes, sir, Your Honor.
Has he provided fully effective and competent legal representation?
Yes, sir.
Okay, Mr. Cormier, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that you plead guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 90 days probated over 1 year, a $500 fine, 40 hours community service, and that is to run concurrent with calls number 329028.
329-028.
Yes, and cause number 21-36540.
Okay, Mr. Cormier, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500, the court cost of $502, which comes to a total of $1,002. And pursuant to the finding that the court made in cause number 329028, the court found that you was indigent, and the court will also make that same finding in this case. Therefore, the fine and court cost of $1,002 will be converted to 80 hours of community service. And Mr. Cormier, you will also be required to pay the probation fee, which is $60 a month, is going to be reduced to the minimum of $25 a month because the court is finding that you are indigent. And you'll be required to pay a $15 per month urinalysis fee and reimburse Jefferson County for the court-appointed attorney's fees of $250. And Mr. Cormier, you will also be required to perform your regular 40 hours of community service in addition to the 80 hours that was converted from the fine and court costs. This case will run concurrent with cause number 329028 and cause number 2136540. Mr. Cormier, you will also be required to adhere to the other standard terms and condition of your probation. Mr. Cormier, do you understand the state's offer?
Yes, sir, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, sir, Your Honor.
Okay. Mr. Cormier, I will, and then Mr. Cormier, do you accept the state's offer?
Yes, sir, Your Honor.
Okay, Mr. Cormier, I will follow the plea bargain agreement that you have entered into with the state. Mr. Cormier, this will conclude your cases. If you do not have anything else holding you in, you should be getting out today. And Mr. Cormier, you can follow the bailiff. This will conclude your case. You have a blessed day. And Mr. Matuska, you are excused and you have a blessed day as well.
Okay, Judge. Chase, lo hecho.
Okay. Oh. Oh, Mr. Matuska. Hey. Oh, okay. Yeah, he just said he left.
He hasn't left.
Okay.
The judge is calling you again.
Yeah, Miss. He's gonna get that.
He's stepping back over, Judge.
Okay, okay. And his client was named Leje.
Now drop down, hit the drop down arrow. Now hit Judge Holmes and you'll be back where you started. There you go.
Yeah, Ryan,
Yes, Judge.
you had another client by the name of Shane Leje. And they said that, was he here? He was here today? He was here this morning on the motion to revoke probation docket.
Oh, okay. Well, I've been on jail run all morning, Judge.
Yeah, I know, but I think he may have, we don't know what happened. We don't know why, why he left or anything.
Well, I didn't tell him to leave. I didn't know he was there.
Yeah, he was here. We were waiting on you. Could you see if you can make contact with him? But I mean, that's what the bailiff said. He was here earlier.
Hmm. Okay, I'll try to call him. You want me to tell him to come on back?
But now he can call if you got him on your phone. If you get on Zoom or whatever, you could just zoom in like that.
Okay.
Okay, all right. We'll talk to you later. You have
Okay.
a blessed day. Okay, we have Mr. Kimmer. Okay. All right, y'all have a blessed day. Okay, Mr. Kimler,
Yes, Your Honor.
we have Mr. Scott Moore, who is apparently you had filed a motion to vacate bond forfeiture and reinstate the bond. And Mr. Moore was informed to, I guess he was instructed to come over because your case was set today at 10:30.
Okay, I didn't have it on my printout, so I wasn't up there, but
Yeah, I don't think it's, yeah, I don't know if it would have been on the printout, but that was because there was a warrant out for him. On this
correct,
case.
Your Honor, he has an active warrant, so.
Okay, is that Mr. Boyd?
Yes, Your Honor.
You'll be handling this?
Yes, Your Honor.
Okay. And Mr. Kimler, do you want to go forward on your motion?
Yes, Your Honor. There was an issue with COVID. It's adumbrated in the motion somewhat. He had been exposed, I believe, and then, had a positive test after the court date, but it's kind of set forth in the motion, and then I can elicit testimony from Mr. Moore regarding the specifics of the COVID exposure and the circumstances surrounding his decision not to come to court due to the nature of his exposure.
Do you want to?
Testimony if the court desires.
Yeah. Why don't you go ahead on now, Mr. Scott? Would you please raise your right hand? Mr. Scott Moore, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you may put your hand. Now, Mr. Kimberly, you can go forward.
Yes, Your Honor. Mr. Moore, can you hear me?
Yes, I can.
You were aware that you had a court date. When was your court date that you missed? What was the date?
August 1st.
On August 1st, what was the reason for your failure to attend court?
I had numerous family members that were exposed, and I was trying to follow protocol in order to quarantine myself. Then I actually did contract the virus shortly thereafter.
So it's my understanding on August 1st, you were around persons to the extent that you were able to say you were exposed to them who had subsequently tested positive for COVID. Is that correct?
Absolutely. They actually tested positive, and I found out that weekend. I did send you a text, and you told me to make sure I keep the documentations.
So on the first, when you were exposed to the persons who had COVID, I suppose they didn't know they had COVID or were positive for COVID at the time you were exposed to them. Is that correct?
It was, I found out that weekend.
I'm talking about them. Did they know that they had been exposed to, or were positive, or they had COVID when you were exposed to them?
It was, they knew that they were positive the weekend that I was exposed after. I mean, I was exposed to them prior to, and I found out the weekend before my court date that I was exposed to them in close contact. And
But my point is, did they know that they were positive for COVID, or that they had COVID when you were exposed to them, or not?
Yes, sir. They informed me on the weekend before my court date.
Well, that they didn't know at the time that you were exposed to them that they were positive. That was my point. In other words,
No.
they're not knowingly exposing people to COVID. Is that right?
No.
Or they weren't in your case? Is that
Yes, sir.
correct?
Yes,
All
sir.
right. So after you were exposed to them, they subsequently learned that they were positive for COVID, notified you. That was before the court date. So in order to abide by the proper protocols, you absented yourself from court because of your exposure to them. Is that correct?
That is correct.
And then you subsequently actually contracted COVID. Is that correct?
That is correct as well.
When did you contract? When was your positive COVID test? What date?
I believe it's somewhere between August 20th and August 24th,
That you actually tested positive. Is that correct?
right after the recommended quarantine time.
All right. That's all I have, Your Honor.
Okay, Mr. Boyd?
No question from the state, Your Honor.
Okay, does, you have any,
The state would just leave it up to the court to make the decision.
okay, well, I mean, Mr. Moore, based on your testimony, I'm looking at Article 22.13 of the Texas Code of Criminal Procedure, say causes which will exonerate. Also, Article 22.125 Texas Code of Criminal Procedure, the powers of the court. One of the powers is to set aside the forfeiture only as expressly provided in this chapter. And in this chapter, which is chapter 22, it states that causes that exonerate, number 3, that the sickness of a principal or some uncontrollable circumstance which prevented his appearance at court, and it must in every such case be shown that his failure to appear arose from no fault of his own. This says the causes mentioned in this subsection shall not be deemed sufficient to exonerate the principal and his sureties if any, unless such principal appear before the court, the final judgment, and you have appeared before the final judgment on a bond to answer the accusation against him and to show sufficient cause for not so appearing. Based on the court's COVID protocol that we have in place, individuals who are exposed to individuals who have COVID are recommended not to appear in person. Now, let me ask you this here. The other question is this here. Were you informed either by your attorney or anyone else that you could appear via telephone or by Zoom?
I was not aware. I had called but I have stayed in constant contact with the courts, my bail bondsman, my attorney, even the warrant officer who came to pick up when I actually did have COVID. So I was not aware of anything that I could do otherwise.
Okay. And Mr. Kimler,
Yes, Your Honor.
you did not advise him that he could appear by Zoom or telephone?
No, Your Honor, I was remiss in that regard. I mean, I prefer to have defendants at court, so it's not my practice to advise them of the availability of the Zoom procedures. I suppose if I know in advance, sufficiently in advance of a court date, that someone is not able to appear because of COVID, then of course, now I would advise them, of the Zoom availability of Zoom to make the appearance. But normally I found it best practice to have people actually appear in court on their dates. But no, to answer your question, no, I didn't advise them of that.
Okay. So apparently, so you was quarantining, is that correct?
Yes,
That's
sir.
what you're telling court. So based on that, the court found that there is sufficient cause for the defendant not appearing on his court date of August the 1st of 2021 because he was quarantining. One, to reduce exposure to other people, and particularly people in the court and the people in the courthouse. So based on that, the court is going to find that he has shown that there is sufficient cause for not appearing, and therefore the court is going to set aside the bond forfeitures, which is in the powers of the court pursuant to Article 22.125 of the Code of Criminal Procedure and Article 22.13 of the Code of Criminal Procedures. So at this time, the court is going to set aside his bond forfeiture. Okay, so Mr. Moore, your bond forfeiture is gonna be set aside. And the bond is the motion is gonna be recalled, and the bond is gonna be reinstated. Okay, Mr. Kimberly, you have anything else?
No, Your Honor, I guess just get him a reset and we'll go from there.
Okay, what's that date?
Thank you, Your
Okay.
Honor. Am I excused?
Yeah, hold on. His case is gonna be reset December 8th of 2021. You're excused and you have a blessed day.
Yes, sir. Thank you.
Scott Moore, you can stand over there and get your reset. Now it's gonna take a while for them to get that warrant out of the system, isn't it?
Yes, sir.
Did we give him a copy of that court order? The copy of that.
Oh, okay, right.
Yeah, we can give you a copy, because if you get stopped, you can show them a copy of that court order.
Yes, Your Honor. Thank you very
Okay,
much.
all
I
right,
appreciate
you
it.
have a blessed day.